Good afternoon, everybody. Welcome to Mediation. Some quick housekeeping things. If you need any sort of accommodation or anything like that, let me know. I'll do what I can to keep up with those kind of things. If there's any documentation that I haven't seen that you would like me to see prior to mediation, or you'd like me to roll over, I would say send it to me now, so all I can do is kind of we go through a little bit of the material. Again, it's good to see you both. There's a couple logistics that I'd also like to talk about. Phones and pagers on silent, please. No recording of the session. You may take notes. The notes, although have to do with because of confidentiality, I ask you not to take notes with you once you leave. Which we'll talk a little bit more about your rights and what it means, confidentiality means in the context of mediation. I'm going to tell you a bit about what mediation is. It's an informal setting which gives you all a chance to work things out on your own terms. I'm sure you know, Mr. Drew, and it lets you make a decision for yourself without the court making it for you, which everybody likes. It gives you a little bit more creativity. Mediation is a growing field with more and more cases being settled. First, that's for a few reasons, right? First, it saves you extra legal fees and out-of-pocket expenses. Second, it lets you get creative. Like I said, the court's decision decides these things depending on particular facts and circumstances. In this way, you can then settle those in your own terms without having the court getting too involved, because they typically do things a specific set of ways. My role as a mediator is essentially I'm an unbiased middleman. I'm here to help you reach a middle ground and maybe walk away with an agreement today. If you do reach an agreement, I will then draft up a mediated agreement, which will be filed with the courts and will be incorporated into a court's order, making it rule of law. So I'm going to explain a little bit about the process itself. Generally, we do joint sessions here where we all kind of sit down together, work out our issues, and we can talk about it here and get it all on the table. If you would like to, which may also be useful, we can do separate caucuses, whereas you have information that you would not like to share from the other party, or something that you would like to keep between me and you, and we can talk about those things outside the presence of the other party. And that's fine. After we talk about things, I guess briefly the general overview. If you decide you want to do separate caucuses, again, let me know. And if we do, what will happen procedurally after that is we'll all come back together and then kind of hammer out the rest of the issues. So a little bit about your rights. What happens here is confidential. Nothing said here, offer made here, may be used in the court of law later if there is no settlement today. Mediation is voluntary, meaning this goes so long as you're willing to let it go. If you decide this doesn't work, you can walk away whenever you'd like, and nothing's set in stone until papers are signed. You have the final say here ultimately. Like I said, I'm neutral. I'm not here to make any decisions. I'm here to help you in making your own decisions and try to inform you as best as my ability. Only you two have the capacity to negotiate this agreement. Now that I've kind of run over my little spiel, I generally start with the plaintiff. If Mr. Drew, if you'd like to go ahead and tell me a little bit about your side of things, we can kind of get this thing going, so long as there's no other questions or concerns prior to starting this up.
No, I don't have any questions, concerns.
Okay.
Great. All right, well, essentially, I'm attempting to be paid for the work that I rendered. I busted my butt for this client. I worked 78 total hours on trying to ensure that my client was made whole, and I'm now no longer being paid for that work. I believe I filed in circuit court. I reviewed a motion to dismiss, and I have applied in appellate court as well. And appellate briefs are a lot of work.
Okay. So you would say the biggest concerns, you've put in a good amount of work for this action that, to my understanding, it was a cause of action about a contractor's work, right? That went awry, and then now you're kind of case or bringing their case to court, and this dispute today is about how much you ought to be paid for that case?
No, absolutely. Breach of contract for contractor work is highly complex work. Working with contractors, general contractors, subcontractors, the various parties that interact with this, it creates an extremely complex web of legal issues.
Okay.
That it takes a specialized mind to work through, and I would like to be paid for my specialized mind.
So let me ask you, what is the amount that you believe is owed to you for the hours that you've worked?
My itemized billing shows $19,500 for 78 hours of work at $250 an hour.
78 hours of work at $250 an hour. Okay. And do you make these itemized bills contemporaneously with the I guess the action that you're doing? So is this something that you, while you're working, after you do whatever, you log that almost contemporaneously with the work itself?
It is our policy to try and keep up with our billing as we do work as much as possible. However, things do get pushed back. We do get busy and things may fall through the cracks sometimes, but our actual itemized billing is a fair and accurate representation of the work that we do for our clients.
Okay. So, Ms. K, I would like, Ms. K. Andrews, I would like you to kind of give me your side of things.
So basically, I hired, I think, his brother, his firm, and then he took over, which is fine, I agreed to that. But my general contractor didn't want to pay the bill, and so I hired Drew to file the complaint for that. And I told him, like, don't spend too much money because his firm charges me a lot of money and I don't have that to spend. So I told him, like, don't spend a lot of money. And then he told me, well, I said that in response to him contacting me saying that the other side said there's an arbitration agreement in mine and my general contractor's contract. But however, they still filed an answer, so my attorney told me he was still going to fight the arbitration.
Did you agree to that?
I did, but I said don't spend too much money.
Right.
And so then I get a bill for almost $20,000, and that to me is a lot of money, so I don't know where that came from. And then additionally, he said he filed an appellate, he filed it for the appeals court, and I never agreed to that. Like, I never wanted it to go to appeals because of how much money it was gonna be. And then I asked him for an itemized list of where all the charges came from in my bill, and he sent me this very generalized, like, blocks, and it didn't have, like, the number of hours for each item. It just had, like, a bunch of items and a big number of hours. And so I just feel like he's overcharging me and trying to cheat me out of my money.
Okay. So can I ask, was generally you've worked with them quite a bit, right? Before this.
Him and his brother, yeah.
Okay. And has these concerns come up in the past?
So I've met with his brother before to talk about my bills at the firm,
Mm-hmm.
and we just don't really agree. Our relationships become very intense, so I don't know if you consider that arising before, but I've discussed it with his brother.
Okay. And generally, when you just had these conversations with the brother, right, as you said, it was raising, what was kind of, do you have a typical amount to which you would pay for attorney's work?
Like $5,000. It depends on the case, though.
Okay. And have you done contracting work with them before?
I have. I did all my legal aspects with his brother.
Okay. Alright. Mr. Bronson, a little bit to some of her points. I see your itemized list here, and I agree that there's not necessarily all that specific. I think that where we're at now is that, obviously she thinks $19,500 is too expensive. You know, I agree that it's kind of murky when I'm looking at your itemized list to say what was what or how long each individual task took. You know, do you think that there's ever been any overestimation of hours, or do you think this is an accurate representation of the work that you've done?
I honestly believe this is an accurate representation of the work that our firms put in for this client. Reviewing motions, reviewing case law, and reading through the lengthy answers that we receive is time intensive. And no, I can agree that there may have been miscommunication on we're going to fight this, not setting how far we were trying to fight it. So I can agree to that miscommunication. However, everything we did prior to the filing of the appeals, like the appellate brief, is, I believe, 100% within what we agreed to do.
Okay, so you would say, I mean, based on that perspective, you would say that maybe there's about 19 hours here, right, that we've talked about that weren't necessarily consented to by the client because there's some kind of miscommunication. So would you say that those would be fair for you to say that at least 19 of those hours probably ought not have been charged to the client?
We would be willing to move on those 19 hours as long as we receive the other 69 hours in payment.
Okay.
Just so our firm does not take a catastrophic loss of what can be boiled down to a minor miscommunication between client and attorney.
So I would like for you to then go ahead and make some, Mr. Bronson, I'd like for you to make some kind of offer. So we have a general starting point and takeoff point to what you think.
Make use of calculator.
Yeah, of course. Go ahead. And then also, Miss Andrews, I would like you to be thinking of a counter offer so we can kind of get a good place to where we want to start off today.
Okay.
So our firm is going to move down. We're going to move down from 19.5 to 17,250. We are taking almost $5,000 off of the price.
Is it 17,000 or?
It should be 17,250. It's 69 times our regular rate of 250 hours.
Okay. Well, it's
$250 per hour.
Well, it is actually. It's because you had 78, so wouldn't it be 59 hours? So it would be 78 minus, you'd say 19.
Oh,
But
yes.
you have 59 hours and you're going to be 55 times the 250 rate, right?
Well, I have another issue I'd like to bring to you.
Sure. Why don't you just, we're going to do it this way. Is we're going to let one party finish,
Okay.
take notes in the meantime, then of course you can go ahead and bring up your concerns and we'll talk about that right after.
Perfect.
Right, so I wasn't adding here. Went to law school because I couldn't do math.
Fair enough.
So, yes, 59 hours times that 250 is, yes, so we'd be moving down to 14,750.
Okay.
And that's just taking away everything we did after June. So that would be, we would not charge for drafting the appeal to the Court of Appeals. It would not charge for receipt and review of court notices and responses to the brief that we filed.
Sure. Alright, Ms. Anders, if you'd like to go ahead and bring up the issue or concern that you have.
So here's my issue. So I did hire Drew to handle this matter for me, because I always work with that firm. My issue is, and I forgot to state this earlier, I did hire him to file the complaint in circuit court. However, he is my attorney, so I'm not understanding why he also didn't go through my contract and like notice that there was an arbitration clause, because this could have fixed all of this and I wouldn't have all these multiple legal fees if we just went to arbitration, or it would have been cheaper. So I'm not understanding why he didn't catch that clause. Like, did he not read my contract that I provided to him? I'm not understanding.
Okay, that's a fair point that you bring up. would say that's also a question for you then, Mr. Bronson. I do believe to when I'm checking in your itemized list, part of the itemized list, I'm not necessarily, let me just check. Part of the itemized list in April was to review the contract. I don't necessarily know how long that was based on the list you gave me, but it's fair to say that that is, you know, that might have been something because there's a 6 months interval, and you want to explain why you didn't bring that up sooner?
So it was our firm's strategy to essentially attempt to get it into court because the actual judges that we'd be going up in front of would be far more friendly to our case than any arbitrator would be. So it was a decision on legal strategy for us to move forward knowing about the arbitration clause in order to attempt to get it in front of court for us to actually succeed on the claim.
Okay. So it's a tactical decision that you made to proceed to court as opposed to going to arbitration.
And the time frame, I believe the time frame got a little extended out due to, I believe, the opposing party taking a long while to respond.
Mm-hmm. And I recognize that things get a little jammed up and the legal process is never fast or easy. So I think it was about 6 months went by, right, after the filing of the initial motion and answer?
Yes.
Okay. So, you know, I think that there's, for better or worse, you made a tactical decision to try to avoid arbitration, but the other side caught it, which to some degree would say that, as especially seeing as that you lost in your first motion to dismiss, I would say that there might be, wouldn't you say there might be a little bit of unnecessarily wasted effort? Obviously, things don't always play out in your hands sometimes, but do you think that you might have spent too much time as opposed to going to arbitration? I understand that, you know, the judge, you think the judge would have been favorable to you, but how do you necessarily know what the arbitrator would have done, right?
Well, typically in our firm's experience, arbitrations have normally gone in favor of those who are drafting the arbitration agreement. So we wanted to make sure that we could stack the cards in favor of our client the best we could.
Sure.
And we did review it, we knew it was there, and we gambled and we lost. It's kind of the nature of the business sometimes.
Okay.
And if there is a claim of an ineffective assistance of counsel, then maybe that can be dispensed of or talked about in another setting. However,
Sure.
here we're mainly looking at the itemized list of the hours we put in.
You know, the whole point here is we want to get this thing settled and move forward to where both parties are no longer disputing over facts around the specific matter, right? So as far as other claims around this specific proceeding, hopefully that we can get those dispensed of today and be in a much more suitable position moving forward. So like you said, you know, actually we'll hold off for a second, Mr. Bronson. I don't believe that Ms. Anders has ever responded to your initial offer.
What was his offer again?
$14,750.
See,
Not having the appeals work at it.
I mean, that's just my issue though. Like, had I known that, because I'm not a lawyer, I didn't go to law school or anything. Had I known there was that arbitration agreement in there, I don't know if I ever would have said, hey, let's take this to court. Because, you know, I agreed to the arbitration in my contract with the contractor. And I mean, that's the exact reason why I have attorneys. And I do have an attorney who's a friend, and he has said to me, and y'all are attorneys, you can tell me this is true, that, I mean, it's ultimately my case, like I'm the decision maker. And if I don't want it to go to court, I think that's my decision, not the attorney's. So I'm not understanding why he thinks I have to pay this when it was his fault for not reading the contract that he billed me for.
Okay, and I understand that there's frustration around the facts involved in the contract.
I mean, this is no small amount of money. This is $15,000.
I agree with you. My question would then be, you to make a counter offer so we know a place to start off with, or at least to come up with a
5,000. I think
Five-
that's what he earned in this
$5,000.
case, if he did what he was supposed to do.
Okay. So let's talk about that a little bit, right? So, you know, as you said, Mr. Bronson, you took a gamble and you ate it, and those things can happen as far as legal strategy goes, and nobody can guarantee that they're going to win every case. That's just a fact of the matter. I think there's a couple more elements to this that I believe would be helpful in kind of determining the amount of payment. I know that Ms. Anders here in the past brought a good deal of money into the firm. I know that probably you would like to continue making money from Ms. Anders, that she does have those, the rental establishments and places of that nature. I think that, you know, somebody eventually is gonna have to eat some sort of loss here, but I think there's a component of continued business that we might wanna take into consideration. So I'm gonna ask you a question, Ms. Anders. If Bronson and Elsmore, the firm Bronson and Elsmore is what you worked with, if they were able to provide more accurate, I would say, itemized statements, would that help with your concerns at all as far as moving forward with working with them?
I mean, it might, however, I'm just not wanting to pay for something I didn't agree to, so.
Sure, and I'm not talking about this specific instance. You know, I'm not talking about the case in front of us. I'm talking about things that's happened in the past and things that might happen in the future, right? You know, they've clearly provided consistent work for you over the past few years, over the past amount of time you've worked with them. I think that there's a reason to why you continue to work with them, and they must do some kind of good job, right? I think that likewise, you know, Mr. Bronson would like to have continued business. Nobody wants to turn down money. So my question to you is if you were to continue, what would it take for you to continue working with Mr. Bronson in the future, not considering the amount that's being disputed in this case?
So,
what would you want from the firm?
I will continue to work with the firm if it's his brother Bobby doing my work. I don't want to work with Drew anymore.
Okay.
So I'll also work with the firm, but I want Bobby to handle my case.
Okay.
Or my legal concerns.
Okay. And then I think there's another element in this case that we haven't really talked a whole lot about. That being the underlying contract suit, right? The contract suit against the contractors. That was the contract to which was in dispute was in the amount of $650,000, right? That's also no small sum of money.
Well, it wasn't for $650,000.
It was $55,000.
Yeah, that's
right.
what I had with my general contractor, and then he messed up, so it was a $55,000 suit.
For the redemption work, it was $55,000, right?
Yeah, the shoddy work, right.
Yeah, that would be how much you'd pay to redeem that. But so my question being is that, you know, you have a $650,000 property with $50,000 worth of property damage. Is that going to be usable until that redemption work's finished?
I'm sorry, I'm not understanding why we're talking about this.
Sure. I think it's important to note that, you know, you have another case in litigation that he tried to take to the Court of Appeals. I think that to say if something were, you know, there's on some circumstances contingency contracts, when you talk about going to court, or, you know, I'm trying to find a way essentially to where if he were to go to the Court of Appeals, and it worked out in your favor, right, and then you were able to redeem the $55,000.
In this case?
No, in the other case,
Okay.
you know, this underlying suit that he has here is really a collections case against you for attorney's fees, right?
Right.
And so it wouldn't be above us to work out a mediated agreement to say that, you know, you would be willing to offer him X amount of dollars here, he continue to work on your case, right? And then if the appeals, which you didn't want necessarily thought to begin with, ends up working out in your favor, maybe there's some money that would be a little bit higher than what you offer today that you'd be willing to pay.
So to answer your first question, although I'm disputing something with my general contractor, that doesn't necessarily mean I didn't fix the work. I just want to get that money back. So
Sure, I was just
my
asking.
property is fine. The
Okay.
second question is, I'm not paying for something I didn't agree to. Even if it works out in my favor,
Okay.
I'm not paying for that.
And that's fine as well. I'm just trying to get some ideas out there.
Yeah.
Okay.
So the
So,
arbitration could have worked out in my favor too, so, and that would have been way less than 19.5.
okay, well, how much money do you think, Mr. Bronson, when you go to arbitration, that also has some sort of preparation involved, correct?
Correct.
Okay. And then when you go to arbitration with said preparation, you essentially present a case to a third party to which they will make a ruling that's not a judge.
Mm-hmm.
Okay. Mr. Bronson, I would like to ask you a question, and generally when you prepare for arbitration, you know, could you give me a ballpark estimate of the time you put in to that kind of preparation work?
To prepare for arbitration can be difficult because it is essentially, for these kind of cases, it is damage control. We're normally not going to walk out of arbitration happy. A good arbitration typically ends with both people being unhappy but made semi-whole. And prep for that can be difficult because we're essentially having to prep less law and more negotiation. So I would say that would take roughly 20 hours worth of preparation.
Okay, 20 hours of preparation for arbitration.
So we would normally bill for that with it'd be roughly $5,000 to do on top of everything else we've done. It'd be another $5,000 to prep for arbitration.
Okay. So that leads me to my next question, Mr. Bronson. What do you think about Ms. Andrews' offer of $5,000? What would you like to say to that?
And that is just vastly too low. I mean, for all the work we put in 78 hours of work on this. And we're willing to move on 19 hours of that work. We can move again if we need. Given the work we did in June, we actually outlined the appeal of it in June. Since that wasn't a block bill, I'd be willing to move off of the June 14 hours and give another 14 hours back to where that 19 plus 14, 33 hours off of the total 78 hours.
So you would essentially be charging for 45 hours, right? And what would the total of that be?
That would be 11,250.
1,250. Okay.
And if we were to do an arbitration, if we got that 11,000, we'd be willing to do an arbitration based on contingency. Contingency that she receives, I would say at least half of what she would get in court.
Okay.
So the contract's for, I believe, what, 55,000? Or yeah, 55,000. If she got half of that out of arbitration, then I would, honestly, that would be a win given how arbitration typically works in this field.
Okay. So here's what I think I've boiled this issue down to, right? And you two can correct me if I'm wrong. Well, there's two issues. One being the disputed sum today, which is, you know, obviously she feels a little bit cheated because she didn't expect you to push that hard, considering she said she didn't want it to be too expensive. Also, at the same time, you believe that you were doing the right thing and most tactful thing legally, which is, you know, your right to do, but of course communicating with your client's key. So I think that really burns to the crux of the issue is, you know, how much are you willing to let go today to keep Kay Andrews as a client, considering the amount of money that she typically generates for the firm? You know, it's not really much of a legal question, but it is more or less a question around what you're willing to do, or what you're willing to compromise on. And I would say the same thing goes for Kay is that she started out saying that she doesn't want to pay any money, and now she made an offer of $5,000. You know, so there's been some wiggle room there. I think also, you know, it's fair to know the Tennessee statute on attorney's fees. And I think that based on your work, as long as you have an itemized list, you can show that attorney's fees are reasonable, that's fine. But that would be a question for the trier of fact to determine the reasonability of that. And I think because your list might be a little, not, this specific list is a little clustered, it might be harder to get past or to get exactly what you wanted. So he made the offer of $11,350. Based off what I just kind of mentioned, would you be willing to knock any more amount of money off of that, or you know, are you going to stand firm and potentially lose somebody who I know has 3 more cases pending with you that would be in the amount of $15,000 of attorney's fees?
So my first issue is, you heard him say, it takes 20 hours to prepare for arbitration, which is the $5,000 that I offered. I'm perfectly fine paying $5,000 because that's what I would have spent. However, you then heard him say 20 hours on top of what we've already done. What you've already done should prepare you enough to go to arbitration, first off. Second, I'm still not understanding, and maybe you're just not addressing it how I want. I don't think I should have to pay for something that he did a mistake on. It's his mistake for not, it's his ethical obligation as an attorney that I hired to say, hey, this is the arbitration. I think this is a better strategy. And then I think it should be my decision if I want to file or not based off that. And I don't think I should have to lose money because he made a mistake. It's a learning curve, I get it. I don't know if he's a newer attorney, but he's newer to me and it's a learning curve, so that's just what it is.
Okay.
So no, I'm gonna stand firm.
Okay. That's I understand your position. Give me one moment.
Okay.
Okay. So here's my issue with that story, Ms. Anderson.
Alright.
I don't disagree with you that he has an obligation to communicate with you. I know that you two had a conversation 6 months after the beginning of the litigation. At 6 months after the beginning of the litigation, when they attempted to force the arbitration clause, you and Drew, Mr. Bronson, had a conversation. Your conversation after 6 months of legal work was, okay, but don't spend too much money when he said you want to fight the arbitration clause. So, I don't necessarily disagree with you that he has a duty to continue to keep you abreast of the situation, but he did briefly at least talk to you and say that he was going to fight the arbitration clause after the filing of the motion.
That's the key term, after. Had I known before, I don't know if I would have done that. I didn't know there was another option.
Okay.
You can't communicate with me after the fact and expect that to be the same as before.
So say, okay. He said it would roughly be about $5,000, I guess, which would be your typical fees based on arbitration. You know, that leads me back to you, Mr. Bronson. Ms. Andrews has found a hill that she's willing to die on, so to speak. So, I guess, that kind of puts a little more burden on you to determine what you'd be willing to do. I would like to say that, based on your conversation, your assessment of how much it would cost to typically arbitrate, that might have been maybe the cheaper of the two options, but like you said, you made a strategic decision, and to some degree, she agreed with it. As far as what we knew about the arbitration clause, or what was known about the arbitration clause 6 months before, I recognize the contract had it in super fine print, which probably made it a little bit harder to distinguish. Can you tell me a little bit about that?
About the arbitration clause itself?
Yeah, so was there anything in the provision of the arbitration clause that, was it required? Or was it just an option to which they could use?
I believe it was a forced arbitration clause, however, it was something that had to be acted upon by the opposing side. And since they had not acted upon it for so long, we assumed they had forgotten about it and we could move forward on this gamble of making sure our client got the most out of this case. Because arbitration very rarely works out in a way that will make both parties truly happy. That's why we would be open to taking the arbitration based on a contingency of her receiving half of what she would have gotten.
So okay, I understand your point. So you're saying that as opposed to in lieu of all of these fees, that you would do something and based on percentage of the arbitration to work out?
So we would, in order to keep Ms. K as a client, Ms. Andrews as a client, we would be willing to drop the fee down to the $5,000. That would be the cost of our prep for arbitration.
Okay.
And then put what was that, 11,000? Exact number is 11,000 for our work on the motion as contingency if she wins. So if she gets at least half of that 55,000 via our work in arbitration.
Contingency fees
now
are.
it's up to 16,000.
Well, hold on, Ms. Andrews. A contingency fee is just essentially you getting to whatever that you earn. He typically can only get up to a third of it, right? So he's saying if you got 25,000, right, then you would then get a third of that, which would come up to the 11,000.
So is it
Correct.
just 11,000 or is it 11 plus 5?
I believe, like you said earlier, attorneys don't go to law school for math, so I think
the contingency would, of course, have that deducted, but we were wanting to really be made whole for what we'd worked on in April and May, but we can conduct out of May's hours in order to hit that third number. So if she got 27.5, let's say she just hit the exact number we needed to hit that contingency.
Okay. So let's see, she got 27.5. It would be 8,250, which would be plus 5,000, which would end up being.
Well, we essentially, what did the number you say? So it was 8,000.
Yeah, it would have been. So if it was $275,000.
So we could take
that being 8,250.
We could take the arbitration case based on us getting 8,000 if we complete it and everything works well. If we do not, move down to that 5,000. We just are charged for the hours. That way we're getting a little bit, a significantly lower sum, but at least a little bit to offset the massive deficit that will come from giving up the full 19,000. But there's also an incentive for us to work as hard as we can on your arbitration.
Here's my issue with that. I'm not willing to do a contingency fee because if I do get my full 55, which I fully think I will because the contractor was shitty, that would come out to 18,150, and I'm not paying that. So I'm not doing a contingency fee.
Oh no, the new contingency fee would be it would just be 8,000 in total for our work on all of this and the arbitration.
So are
And
you
if
saying
we
that,
end up losing the arbitration, 5,000, which would be just the cost of the hours we put in.
so what he's essentially saying is that as opposed to that 0.3 number, right,
Mhm.
the 30% of the 27.5 number, in lieu of the actual third of whatever arbitration would be, he's taking a half of maximum due with the 0.3. So saying his contingency fee would be at most 8,000. You could say a third, right, or up to 8,250. Meaning that if you got lower, right, than the 50%, say things don't work out your way, you never know. So say if you got, $10,000 back, you would only get $3,000, $3,300 off the top. I think that would be fair to say, well, one, it would give you the opportunity to work as hard as you could. Two, you would be capped out to a degree in how much money you can make, which would come to a closer middle ground. But then also,
I believe there might be miscommunication there.
okay, so.
It was at most 8,000, at least 5,000.
Right, but you're saying 8,000 in addition to the 5,000, right?
Oh, no, foregoing the idea of us getting a third of whatever she gets from arbitration. It is, at most from arbitration, we will take 8,000. At least from arbitration, we take 5,000.
So that might be even better, really, because that would say the most that they would possibly get from you is $8,000, right? And then also, the minimum that they would get from you was the 5K to which you offered, depending on the results of your arbitration agreement.
I'll do it if we can put it down to 7 instead of 8.
7 instead of 8.
Mm-hmm.
Okay.
So at most 7,000, minimum 5.
And what do you think about that, Mr. Bronson? I know.
What is the mathematical reason
So-
behind that?
There's no mathematical reason, it's the principle. You fucked me over, it's the principle.
The principle. Well, I understand that you have some feelings towards Mr. Bronson here, but as you said before, you've had generally good relationships with the business.
With his brother.
With his brother, but his brother's part of the business.
Mm-hmm.
More or less, you generally had good terms with the business. Things didn't necessarily work out the way you wanted them to. I don't think he was intentionally trying to do anything to you.
We can disagree.
Sure, but there's nothing that he said to me that would make me think that he was intentionally trying to do something to you. Not only because I think the reason that evidence is to me is that he says, we want to keep her as a client. I'm willing to budge here because.
Well, they have a secondary gain from keeping me as a client.
Sure, I'm not saying that they wouldn't.
I'm
have
one of their
anything
biggest
wrong.
clients, so.
Okay, and I'm not disagreeing with anything about that.
So I think 7,000 is a fair counteroffer.
Okay. Mr. Bronson?
Given that we've already moved down significantly from what was initially owed, just to maintain your clientele, because again, we do care about our clients, we do care about keeping our clients. We could move down to 7,000 for the sole purpose that it is unlikely that it's arbitration. Arbitration is very unlikely we'll get 8,000 anyway. So what's the difference of $1,000 when it's very unlikely this is not going to happen, because arbitration is the less than satisfactory result for this case.
In your opinion?
In his legal opinion.
In his opinion? Yep, 7,000, final offer.
Now, just the 7,000, correct?
7,000 max, 5,000 minimum.
All right. 7,000 max, 5,000 minimum.
Okay. Now, this leads me to wonder if there's anything that we can do in the future to kind of, dispense with, I think that there's an issue with maybe how a communication gap. I wonder if there's anything that we could offset by the order that would help bridge that and maybe just sweeten the pot in general.
So, this case, as it is costing our firm a massive amount of money,
Sure.
has led to a kind of a revamping of how we do our billing. So block billing is a thing in the past.
Okay.
So and our itemized billing will now be daily instead of monthly. So that will be a much more cohesive sense of what the work is on day to day. to further provide for our clients to show that we are doing what we say we're doing.
Great.
I would also like in the order that Drew no longer works on my cases. It's only his brother Bronson,
So,
Bobby Bronson.
may I?
Please go ahead.
So we can do that. We can put in order that I'll no longer be in your case. That is fine if you'd like other representation. You can, however, limiting it to just Bobby may be too heavy of a burden on our firm for us to be able to operate because he's a very talented man.
How about this? I think I have come to a pretty good middle ground with this one. How about instead of saying that the only person allowed to work on your case is Bobby Bronson?
I misspoke. Anyone other than Drew.
Well, how about instead we could say, yeah, maybe something along the lines of, we would like Bobby Bronson to be the lead on your case, although, you know, the other attorneys at the office may work on it, because then at least the buck stops with the person to whom you think you have the most trust with.
That's okay.
Right?
We can do that.
So, you know, say if Drew touches your case, then you at least are reassured that Bobby is on the other end of it and can make, you know, and then also we might just say that Bobby Bronson could be Bobby Bronson or maybe his associate, whoever's not, would be a point of contact. So,
That's a good compromise. I'll do that.
okay. Well, I'm gonna go ahead and draft an order, a mediated agreement for both of you to sign that kind of accurately reflects what we've agreed upon here today. Then, of course, nothing's set in stone until you both sign it. I'll go ahead and get that drafted, and we'll finish up.
Can there be one additional thing added for the sake of both our firm and for the firm's reputation, but also for Bobby's reputation? Is there an agreement that the negotiations here are covered under a non-disclosure agreement?
You know, that's a fair point. I think that to some degree, you know, we've come to terms on how we ought to be able to help you out to get disclosure. You know, everyone's come to terms, kind of figure out a price that's doable, and then to make sure that obviously you don't have further problems with the firm. Do you think it would be fair to say that for the sake of the firm's reputation, that we also draft or include in the agreement that there will be nothing said about the case, the trial, mediation, and things that surround the litigation of this specific case?
That's fine.
Okay, great. All right, again, I'll go ahead and get this together. We'll draft up a mediated agreement. You will sign it. I'll get you out of here. You'll pay me all your money.
Yay.
Really for me?
I was angry. Hold on. I'm gonna have to put my password in. It's still recording though.
Oh, so.
There you go. You can hit.
I need myself.
Jeez Louise.